Well, hello everybody. Yes, I know I'm a day late with this, but this is what it's like coming back from vacation. Still behind on a couple of projects, and the guy came to paint the porch this morning. Joys of being a homeowner. All these interruptions throughout your day, but I'm going to sit down and get this done because this is back in Cadre v. Meta, and we covered Judge Alsup's decision over in Bartz v. Anthropic. Meta wasted no time in presenting this to Vince Chhabria, and these are both in the Northern District of California. But the interesting thing is what Judge Chhabria is doing. I think I've lost a little bit of respect for him because it seems like he's trying to split the baby. He's trying to give the plaintiffs a lot more than what they want. And I realize that in a way, that's what you're supposed to do in a summary judgment, but we'll get into it. I think you'll see that this guy has been way too deferential. Starting here on page 3. Again, this is the same page numbers top and bottom as the PDF file, so we don't have to worry about it. So right off the bat, he says, the company's use of the works is transformative. Training in AI is transformative. If it's not transformative, nothing else is. As a factual matter, there's no disputing that. And as a legal matter, it's true that you're less likely to be liable for copyright infringement if you're copying the work for a transformative purpose. In that situation, you're more likely to be protected by the fair use doctrine. But as the Supreme Court has emphasized, the fair use inquiry is highly fact-dependent, and there are a few bright-line rules. There is certainly no rule that when your use of a protected work is transformative, this automatically inoculates you from a claim of copyright infringement. Yes, there is. Remember Nichols v. Universal? We talked about that and how being transformative is a concept that predates the rest of fair use, and in and of itself, if something is sufficiently transformative, nothing else matters. And here he is going against that principle. Copying the protected works, however transformative, involves the creation of a product with the ability to severely harm the market for the works being copied, and this is going to be like his major thesis throughout this, and thus severely undermine the incentive for human beings to create. Under the fair use doctrine, harm to the market for the copyrighted work is more important than the purpose for which the copies are made. No, it's not. Because the purpose is the part that has to do with our First Amendment rights. And so remember, the reason for this fair use thing is a clash between the power of the government in Article 1, Section 8, Clause 8 to give monopolies based on copyrights and patents, and our First Amendment rights to free speech. When those butt up against each other, how do you figure out which one's supposed to apply? Well, that line is fair use. So always remember that, and it's something that kind of gets ignored in these copyright cases, unfortunately. Maybe when these get up to the Supreme Court, one of them will remind the justices of that. So according to Judge Alsup, and according to anyone with a brain, this is not the kind of competitive or creative displacement that concerns the Copyright Act. It's only direct substitutes, either copies or knockoffs or something like that, not something that's transformative. But Chhabria says, this inapt analogy is not a basis for blowing off the most important factor in the fair use analysis, which is going to be factor 4. How is it most important, though, given that the first factor is the bigger protector of the First Amendment? But we'll get into those. The suggestion that adverse copyright rulings would stop this technology in its tracks is ridiculous. These products, and this is a big problem, pay attention to this, these products are expected to generate billions, even trillions of dollars for the companies that are developing them. But that's only true of the big companies. Not the small developers, not the open source projects. But he says if using copyrighted works to train the models is as necessary as the companies say, they will figure out a way to compensate copyright holders for it. Just figure it out. Figure it out somehow. I mean, okay, if you're as big as Meta, or Google or someone like that, you could probably do it. What if you're just one of those guys training models and posting them to Hugging Face or Civet AI? And you're making important contributions to the community such as LoRa's and embeddings and retrainings and fine-tunings and things like that. So that's a problem. That mindset is a problem. But even with that undue deference to the plaintiffs offer two primary theories for how the market for their works are affected. They contend that Llama is capable of reproducing small snippets of text from their books, and they contend that Meta, by using their works for training without permission, has diminished the author's ability to license their works for the purpose of training large language models. As explained below, both of these arguments are clear losers. Even with that, boom. He's going out of his way to be on your side, plaintiffs, and you still lose. And again, maybe that's what you're supposed to do in a summary judgment, but his whole view of fair use, I think, is way out of whack, and Judge Alsup, I think, has a much better handle on it. And remember, Judge Alsup was the Oracle v. Google judge. So I would think you would want to listen to him. Given the state of the record, the court has no choice but to grant summary judgment to Meta on the plaintiff's claim that the company violated copyright law by training its models with their books. But in the grand scheme of things, the consequences of this ruling are limited. This is not a class action, so the ruling only affects the rights of these 13 authors, not the countless others whose works Meta used to train its models. And, as should now be clear, this ruling does not stand for the proposition that Meta's use of copyrighted materials to train its language models is lawful. It stands only for the proposition that these plaintiffs made the wrong arguments and failed to develop a record in support of the right one. God, I hate it when judges do this. I don't know if this guy's channeling John Roberts or what, but that's the same kind of thing. And what we see over these next pages, and we'll be skipping a bunch of it, I'm really just going to read out one part, but as you can see, when you look through this, he's paying way too much attention to Warhol and Harper and Row, and not enough to the stronger fair use cases like the ones we've covered. He says, the key question in virtually any case where a defendant has copied someone's original work without permission is whether allowing people to engage in that sort of conduct would substantially diminish the market for the original work. But again, that's only in a particular way. That's only if it's a copy or a derivative work, not if it's transformative. That's how it's supposed to be. And that's why so many people complained about Warhol. Because even though the Supreme Court found the right way, just because of the way they argued it, it just ended up introducing all this confusion. So hopefully that gets clarified at some point. Alright, so we're going to move ahead to where we're actually looking at the factors of fair use. Factor 1, the purpose and character of the use. This factor favors Meta. There is no serious question that Meta's use of the plaintiff's book had a further purpose and a different character than the book's, that it was highly transformative. Good. There's really no other way he could have done that. If he hadn't concluded that, I'd really be wondering what's wrong with him. Bottom of page 18, also relevant is the commercial nature of Meta's use. And this is something the judge also made really clear, but here Judge Chhabria says, although Llama is available under a free license, it was ultimately developed for commercial reasons, and Meta expects it to generate $460 billion to $1.4 trillion in revenue over the next 10 years. But remember, as Judge also pointed out, commercial use is only supposed to be indicative, not dispositive. And again, what about the smaller open source projects? The ones that aren't going to be making trillions of dollars. The ones that people are actually donating their time and money and GPU cycles and everything else to make. What happens to them? Just because there are some larger companies that can handle that major expense doesn't mean you get to force everyone to handle that expense. Because otherwise, that's just another way you're going to favor the big corporations over the little guy. But he says that, nevertheless, commercialism isn't dispositive of the first factor and tends to be less important when the secondary use is highly transformative. Thus, while the profit Meta stands to gain from its development of a product trained on the plaintiff's works is relevant to the fair use analysis overall, it does not tilt the first factor in the plaintiff's favor. The plaintiffs are wrong that the fact that Meta downloaded the books from shadow libraries and did not start with an authorized copy of each book gives them an automatic win. To say that Meta's downloading was piracy and everything else stealing the fires of Prometheus, you remember when we went all that? That was the Bart's plaintiff, not these, but it was the same kind of thing. And thus cannot be fair use begs the question, because the whole point of fair use analysis is to determine whether a given act of copying was unlawful. Exactly as I've said several times before. But Meta is also wrong to suggest that its use of shadow libraries is irrelevant to whether its copying was fair use. It's relevant, or at least potentially relevant, in a few different ways. First, Meta's use of shadow libraries is relevant to the issue of bad faith, but as we covered, bad faith is not an issue here. It's either infringing or it isn't. But he says, but even if bad faith is relevant, it doesn't move the needle here given the rest of the summary judgment record. Second, downloading copyrighted material from shadow libraries would be relevant if it benefited those who created the libraries and thus supported and perpetuated their unauthorized copying and distribution of copyrighted works. In the vast majority of cases, this sort of peer-to-peer file sharing will constitute copyright infringement. Some of the libraries Meta used have themselves been found liable for infringement. So, if Meta's act of downloading propped up these libraries or perpetuated their unlawful activities, for instance, if they got ad revenue from Meta's visits to their websites, then that could affect the character of Meta's use. Seriously, Chhabria? Ad revenue? Do you not get how this works? They might have loaded the page once or twice just to get the torrent file and download it. Okay, so they might have given them a few hundredths of a cent. Do you have any idea how minimal that is? They make that money because they have tons of users going to their sites. But the contribution of any single user is minuscule. And also you can run ad blockers. But the plaintiffs have not submitted any evidence about this. Meta's downloading is a different use from any copying done in the course of LLM training, but that downloading must still be considered in light of its ultimate, highly transformative purpose, training Llama. And unlike Bart's v. Anthropic, there's no evidence here that they did anything else with that data other than train LLMs. Factor 2, the nature of the copyrighted work. This factor favors the plaintiffs, just like Judge Alsup said. Meta argues that this factor favors it anyway because Meta only used the plaintiffs' books to gain access to their functional elements, not to capitalize on their creative expression. In each case, the Ninth Circuit held that the defendant's fair use defense would likely succeed because, although the defendants copied expressive elements of the plaintiff's code, they did so only to access the code's unprotected functional elements. But unlike the uses in these cases, Meta's use of the plaintiff's books does depend on the book's creative expression. As Meta itself notes, LLMs are trained through learning about statistical relationships between words and concepts and collecting statistical data regarding word order, frequencies, grammar, and context. Word order, word choice, grammar, and syntax are how people express their ideas. Again, looking at Harper and Row, I hope I don't have to explain to you why that's BS. Oh, look, it uses nouns and verbs, and so do creative people. Oh my god. Alright, factor 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. This factor favors Meta, even though it copied the plaintiff's books in their entirety. The amount that Meta copied was reasonable given its relationship to Meta's transformative purpose. Factor 4, and this is going to be the big one, this is what we're going to spend most of the time on. The effect of the use upon the potential market for or value of the copyrighted work. There are at least 3 ways a plaintiff might try to argue that the defendant's copying harmed the market for the works. The plaintiff might claim that the model will regurgitate their works. The plaintiff might point to the market for licensing their works for AI training. And the plaintiff might argue that, even if the model can't regurgitate their own works or generate substantially similar ones, it can generate works that are similar enough in subject matter or genre, which are not copyrightable, that they will compete with the originals and thereby indirectly substitute for them. Yeah, but that's not a substitute. That's just a competing item. In this case, the first 2 arguments fail. The third argument is far more promising, but the plaintiff's presentation is so weak that it does not move the needle or even raise a dispute of fact sufficient to defeat summary judgment. The plaintiff's primary theory of market harm is that Meta's unauthorized use of their books for LLM training harms the market for licensing their books for that purpose. The plaintiffs devote nearly all of their discussion of the fourth factor to this theory. But whether such a market exists or is likely to develop is irrelevant, because this market is not one the plaintiffs are legally entitled to monopolize. You don't get that under copyright law. The third way is by helping to enable the rapid generation of countless works that compete with the originals, even if those words aren't themselves infringing. But if they're not infringing, what's the problem? Oh, well, they did a lot of non-infringing stuff. Who cares? It's still not infringing. I don't know how you can say something is non-infringing, but you pile up enough non-infringing stuff, it somehow becomes infringing at some point. That makes no sense. Nonetheless, that's his argument, and it's an argument that Judge Alsup debunked pretty thoroughly, I thought. People could thus use LLMs to create books and then sell them, competing with books written by human authors for sales and attention. Wah! They're competing with us. What do you think this is, a free market or something? While AI-generated books probably wouldn't have much of an effect on the market for the works of Agatha Christie, they could very well prevent the next Agatha Christie from getting noticed or selling enough books to keep writing. But how does that make it copyright infringement? Just because it has to compete amid a bunch of other stuff. I mean, I get it. I'm a YouTuber. There's a lot of people that are just AI generating videos automatically and just throwing them up. That's not the problem. Is the fact that for some reason, YouTube is promoting their videos and not ours. Don't know why, but that's the crazy algorithm they have. Meta and its law professor Amiki, as well as the Matthew Sagg article cited above, argue that market dilution does not count under the fourth factor. They argue that harm caused by an LLM's output is only relevant if the outputs are themselves infringing. But that can't be right. Why not? It sounds right to me. Does it sound right to you? Leave a comment. See if you can tell where his mind is going there. Books on the same topics or in the same genres can still compete for sales with the books in the training data. And by taking data from those books, or by flooding stores and online marketplaces so that some of those books don't get noticed and purchased, those outputs would reduce the incentive for authors to create the harm that copyright aims to prevent. Just look at my coverage of Judge Alsup's decision to see why that's ridiculous. Indirect substitution is still substitution. If someone bought a romance novel written by an LLM instead of a romance novel written by a human author, the LLM-generated novel is substituting for the human-written one. But again, that's not what substitution means under the Copyright Act. That's not what it is. It's just a competing work. This case is different. This is not a case where an original work is being compared to one secondary work, nor is this case like the previous fair use cases involving creation of a digital tool. I don't know, AI sounds like a digital tool to me. This case, unlike any of those cases, involves a technology that can generate literally millions of secondary works with a minuscule fraction, he misspelled minuscule, with a minuscule fraction of the time and creativity used to create the original works it was trained on. No other use, whether it's the creation of a single secondary work or the creation of other digital tools, has anything near the potential to flood the market with competing works the way that LLM training does. And so the concept of market dilution becomes highly relevant. Again, I don't see how you do a few of them, it's not infringing. You do a bunch of them, it suddenly becomes infringing. I don't see how you get there. I don't. I really don't. Anyway, top of page 33, he says that the question is whether these plaintiffs have presented enough evidence to raise a genuine dispute of material fact sufficient to give the question of market dilution to a jury. The answer is no. The plaintiffs only asserted two types of market harm: that users of Llama can reproduce text from their books, and that Meta's copying harmed the market for licensing copyrighted materials to companies for AI training. As for market dilution, the plaintiffs never so much as mention it in their complaint, nor did they mention it in their own summary judgment motion. So the only point he thinks is valid is the point they didn't raise. Is Llama capable of generating such books? If it isn't currently, will it be capable of doing so in the near future? Presumably the answer is yes, but that's not a foregone conclusion. And what are these AI-generated books? Do they compete with Sarah Silverman's memoir? With plaintiff Matthew Kahn's book of short stories? What impact does this competition actually have on the sales of books it competes with? Does it drown out those books entirely? Does it just chisel at their sales at the margins? Or, as discussed above and seems likely, does it depend on the book? How does the threat to the market for the plaintiff's books in a world where LLM developers can copy those books compare to the threat of the market for plaintiff's books in a world where developers can't copyright them? There is no hint of that in the briefs or evidence presented by the plaintiffs. And remember, one big difference with this case is that it's gone far enough that fact discovery is closed and expert discovery is closed. We're past discovery now. All of the facts that you want to put in the record have to have been put in by now. It's all closed. Where a defendant introduces evidence of a lack of market harm, and the plaintiff fails to introduce empirical evidence countering such a showing, the fourth factor should be weighed in the defendant's favor. That is exactly what happened here. Meta introduced evidence that its copying hasn't caused market harm. The plaintiffs presented no empirical evidence to the contrary, no evidence that the copying has already caused market harm, and no evidence that the copying is likely to cause market harm in the future. All the plaintiffs presented is speculation, and speculation is insufficient to raise a genuine issue of fact and defeat summary judgment. Yep, even after all that, he's still giving it to Meta. The Supreme Court has stated that no inference of market harm is applicable to a case involving something beyond mere duplication for commercial purposes. Here, by contrast, Meta's use is highly transformative and has a purpose well beyond that. On this record, then, Meta has defeated the plaintiff's half-hearted argument that its copying causes or threatens significant market harm. That conclusion may be in significant tension with reality, but it's dictated by the choice the plaintiffs made to put forward two flawed theories of market harm while failing to present meaningful evidence on the effect of training LLMs like Llama with their books on the market for those books. And he mentions two other issues as well. Whether Meta's use of shadow libraries benefited those libraries or their other users. If it did, this will be relevant to the fourth factor. It would mean that Meta's copying helped others acquire copyrighted works, potentially including the plaintiff's works, without paying for them. And so this is similar to what we saw over in Bartz v. Anthropic. If the only thing you did with the copies is use them for LLM training, and LLM training is transformative, then it's fine. If you did other things with them, other things that were infringing, then that's a different matter entirely. But again, that would turn this into a piracy case, not an AI case, and it would have nothing to do with AI. It would have to do with, like, when they downloaded it, if they shared it with other users, or in the case of Anthropic, when they said, okay, we're done using this for LLM training, but we're going to keep it around anyway. We might use it for other things. And all their engineers accessed copies and used them for other things as well. Here, there's no evidence of that, but there is the question of, when they downloaded all the copies, did they share them with others? But although the plaintiffs discussed Meta's use of shadow libraries at length, they did not argue that it had these effects or was relevant to the fourth factor beyond allowing Meta to get the books without paying. That was the only thing at issue. It's all about the moolah. So his conclusion, page 39, no previous case has involved a use that is both as transformative and as capable of diluting the market for the original works as LLM training is. So no previous case answers the question whether Meta's copying was fair use. It seems like the plaintiffs will often win, at least where those cases have better developed records on the market effects of the defendant's use. No matter how transformative LLM training may be, it's hard to imagine that it can be fair use to use copyrighted books to develop a tool to make billions or trillions of dollars while enabling the creation of a potentially endless stream of competing works that could significantly harm the market for those books. Well, Chhabria, I guess I just have a better imagination than you do. In this case, because Meta's use of the works of these 13 authors is highly transformative, the plaintiffs needed to win decisively on the fourth factor to win on fair use. And to stave off summary judgment, they needed to create a genuine issue of material fact as to that factor. Had the plaintiffs presented any evidence that a jury could use to find in their favor on the issue, Factor 4 would have needed to go to a jury. Or perhaps the plaintiffs could have made a strong enough showing to win on the fair use issue at summary judgment. But the plaintiffs presented no meaningful evidence on market dilution at all. Absent such evidence, and in light of Meta's evidence, the fourth factor can only favor Meta. Therefore, on this record, Meta is entitled to summary judgment on its fair use defense to the claim that copying these plaintiffs' books for use as LLM training data was infringement. And summary judgment will be granted for Meta in a separate ruling on the plaintiff's DMCA claim. That's coming later, but again, that makes it a piracy case, not an AI case. Training in AI is transformative. So this is a victory for Meta. It's kind of like the opposite of the last one. This is a big win for Meta. Not sure it's that big a win for fair use, because Chhabria was very deferential to plaintiffs. He was really trying to split that baby. But then, of course, they still lost, because as we repeatedly covered, they had nothing. But still, there are a lot of concepts here that I'd hate to see made precedent for future fair use cases, such as like mere competition being relevant to the fourth factor. What's that all about? That's never been the case. You got that one wrong, Chhabria. And again, it also seems like we've gotten away from the First Amendment aspect of the whole thing, which I think is one of the most important things we need to keep in mind. Again, I'll continue to follow this. Even though for the LLM part of this, it seems like it's pretty much over, but we'll see what they have to say on the DMCA claims, on whether that has anything to do with LLM training or not, or if it's just a separate piracy case like Bart's v. Anthropic has become. And of course, I'm following all the others too, so I'll let you know when they happen. I'm the only one doing this, remember. I'm the only one actually going through all of these. The news media is lying to you about these when they deign to cover it at all. Just look at what they're saying about this decision. They lying to you, just like they lied about Judge Alsup's. So come here if you want the truth. I'll always be here, willing to give it to you, no matter what. So thank you so very much for watching. Comments for the comment god, shares for the share throne. Please hit like, subscribe, and the bell, and of course, donate.bogosity.tv. Support this channel all sorts of ways with one-time donations or by becoming a regular supporter, where you can get these videos early and ad-free, and other benefits as well. Thanks again, and until next time, stay strong and be free.